Just want to point out some of the sources that are available now for administrative law research in Massachusetts. The picture gets brighter every year in terms of basic primary source material being available in online sources and also print sources. There are now two publications, one in the Mass Practice series on administrative law and another one published by Lexis that some of us on the panel have contributed to. So, going back. In the materials, I've included a couple of our research guides on Massachusetts administrative law. These have been put together by the reference staff here at Social Law that outlines what's available. And as I say, this is growing all the time. There's also a guide to the Massachusetts Register in particular to find where regulations were initially published or amended. And that is a source that more is being made available online. The state library's program of the digital repository called DSpace has materials from the executive agencies and the legislature on their various that include their various documents and decisions, and that's been growing. The Secretary of State's office has put up all of the cumulative tables that traditionally we use to see where regulations came into original force and also when they were amended. You'll find in the paper, Massachusetts registers every issue a cumulative table for the current year that goes through all of the sections of the Code of Regulations that have been amended in the current year. And as well, the Secretary of State's office now publishes a database that we have available here at the library where you can search for the regulations along with the forms that the agencies file as they publish new regulations, and you can also search for the notices of proposed regulations in that database to get some more background as to the need for the particular regulation. As I mentioned, the DSpace digital repository that the state library does is a continuing growing resource. Please take advantage of that if you haven't been to that part of the state website, mass.gov. Go to mass.gov/LIB and you'll be able to access at this point literally millions of pages of documents, including legislative material, all the acts and resolves, all of the House and Senate bills going back hundreds of years, and then materials from departments and agencies, a lot of them older archival material, but also a lot of current documents. Among them, I've already mentioned, are all of the cumulative tables done by the Secretary of State's office to show the changes to the Code of Regulations going back as far as 1976, and there's a table for every year that you can check if you're going back to see where older versions of regulations were first published. The Secretary of State's office also has a very useful citizen's guide to state services that gives descriptions of the departments and agencies and current contact information. They come out with a print edition every couple of years, and they keep up to date online. So that's available there on mass.gov too. So keep that in mind when you're looking up a particular agency. There should be an entry for all of them. The library has been involved in an archival project the last year or so with the LLMC database. That is one that's available to all members as part of our set of databases. And the aim of it is to eventually have a complete archive of the Code of Regulations for every year, at least back, the plan now is at least back to 1976. Right now, we have available 2017 and 2018, and that project is, we hope, continuing, and will eventually have a complete archive for you that would be searchable with PDFs of all of the older versions of the CMR. As well, there's a digitization project on the same line for all of the individual Massachusetts registers. So that would get all of that information available, including the regulation filing material done by the agencies when they published regulations originally or when they amended them. Other of the databases, the big ones, Lexis and Westlaw, continue to add Massachusetts material. I've included in the materials Lexis's offerings as far as reports of decisions from state agencies, and have one in there for Westlaw as well. Lexis currently has the full text of all the Massachusetts registers going back to 1995. I don't know whether they're planning to go any farther back, but it is a decent archive that's available there if you have access to Lexis. And if the reference librarians at the library do, if you have a question along those lines, please give us a call or an email, and we'll take a look for material that you may be trying to find from an old register. And just to sum up, the situation is getting better. When I started as a law librarian, it was really hard to find the decisions of a lot of the agencies. But that is really improving as databases continue to compile them, and there's still some that it is tough to find material from, but anytime that you have an issue trying to find material that doesn't seem readily available, give us a call here at the library, and we'll see if we have it available in either print or online. Any questions? Well, thank you very much.
Good afternoon. I'm Rob Quinan. For the past 11 years, I have served as either Deputy Chief of the Attorney General's Administrative Law Division or the Managing Attorney, and for 10 years prior to that, I was Aligned Assistant Attorney General in the Administrative Law Division. I thought I would begin my remarks today by quoting a former New York Times Supreme Court correspondent, the estimable Linda Greenhouse. In an op-ed published about 10 days ago, she wrote the following: "Administrative law may sound like a boring subject, but it isn't. It's both fascinating and, in the 73-year history of the Administrative Procedure Act, more important than ever for providing the legal structure in which encounters between citizens and their government takes place. The Administrative Procedure Act doesn't tell government what to do. It simply requires that actions of agencies must be supported by reasoned decision-making. When challenged, agencies have to provide explanations that are plausible and consistent rather than arbitrary and capricious." I know that I'm preaching to the choir here when I say that administrative law can be endlessly engrossing, but it's interesting to see how it engages lawyers from many different sectors. By a show of hands, please tell us who here is at least a part-time adjudicator. Very good. Who works for a professional licensure board? Who works for another state regulatory agency? Who represents mainly municipal clients? Who works in academia, libraries, or publishing? Who works for the court system? Who represents mainly plaintiffs? Anyone else I haven't labeled yet? Okay, but that's quite a few different groups that are represented right here. And I hope that today this panel will offer something of value to each of you. We extended the program length by half an hour this year in order to allow for plenty of Q&A, and feel free to raise your hand if you have a question that you'd like to direct to any one of us. So now, without further ado, from this grand promise of fascinating subjects and inquiries, I'm going to move on to my riveting topic of summary decisions and agency impositions of sanctions. My tips for ensuring that a truncated agency adjudication is defensible on judicial review. First, some guiding principles for the proper use of any summary decision process. A motion for summary decision is the administrative equivalent of a motion for summary judgment in court. It may properly be granted when all that is to be resolved through adjudication is an issue of law rather than of fact. Interestingly, the Massachusetts Administrative Procedure Act, first enacted some 65 years ago, contains no provision for summary decision by state administrative agencies in the course of adjudicatory proceedings. About 50 years ago, the Administrative Conference of the United States adopted recommendations regarding what they termed summary judgment in administrative adjudication. I'd like to quote a 1969 decision from the nation's second most important court when it comes to administrative law, the D.C. Circuit. They wrote, "The right of opportunity for hearing does not require a procedure that will be empty sound and show, signifying nothing." So the court there is articulating perhaps the most enduring justification for summary decision: efficiency. For many years now, our Massachusetts standard adjudicatory rules of practice and procedure have included this provision for a motion for summary decision. Quote, "When a party is of the opinion there is no genuine issue of fact relating to all or part of a claim or defense, and he is entitled to prevail as a matter of law, the party may move, with or without supporting affidavits, for summary decision on the claim or defense." For the full provision and citation, please see page 30 of your handout book. Now, this provision is plainly quite similar to Rule 56 of the Rules of Civil Procedure, which provides for summary judgment where the pleadings, depositions, answers or interrogatories, and responses to requests for admission, together with the affidavits, if any, show that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. Well, given that the core purpose of adjudicatory hearings is to resolve disputed factual issues, logically, an agency ought not to be compelled to conduct an adjudicatory hearing where no disputed adjudicative facts are in play. RSJC said as much in the 2005 case of Coburn versus Board of Registration in Medicine. Although the statute governing the disciplining of physicians confers a right to a hearing, the SJC wrote, and I quote, "Neither the statute nor the due process required the board to hold a hearing to take evidence concerning undisputed facts. Such a hearing would be a meaningless exercise." As I will discuss later, however, the court did go on to say that some form of hearing may be required in the sanction phase to enable a party to present, for example, mitigating factors. Hence, even where a clear right to a hearing exists, either as a matter of statute or constitutional requirement, state agencies may establish reasonable and fair threshold requirements, such as first showing a genuine issue of material fact that must be satisfied by a person seeking an adjudicatory hearing. Again, in a more recent 2014 case, the SJC recognized this, stating, "Not all claims that are entitled to an adjudicatory proceeding necessarily reach the hearing stage. A directed decision may properly be entered when the party seeking relief has failed to show by a preponderance of evidence entitlement to the favorable administrative determination sought from the agency." That's the Pepin case cited in your material. I want to stress, though, that what our appeals court wrote some 40 years ago, administrative summary judgment procedures do not transgress statutory or constitutional rights to a hearing where those procedures are such that they allow the agency to dispense with a hearing only when the papers or pleadings filed conclusively show on their face that the hearing can serve no useful purpose. Similarly, the First Circuit held 25 years ago, due process simply does not require an agency to convene an evidentiary hearing when it appears conclusively from the papers that on the available evidence the case can only go one way. There's a great temptation, I think, on the part of agency attorneys and some adjudicators to take the summary decision shortcut whenever possible. It is essential, however, that the test for dispensing with an evidentiary proceeding be applied rigorously. A determination whether there exists a genuine issue of material fact that precludes summary decision requires the adjudicator to consider whether the competent evidential material presented, which often will include sworn affidavits, when viewed in the light most favorable to the non-moving party, are sufficient to permit a rational fact finder to resolve the alleged disputed issue in favor of the non-moving party. When the evidence is so one-sided that one party must prevail as a matter of law, then of course summary decision is plainly appropriate. Concerning the requirement that there be a genuine issue of material fact in order to proceed to an evidentiary hearing, the U.S. Supreme Court's summary judgment standard is instructive. They've written, "As to materiality, the substantive law will identify which facts are material. Only disputes over facts that might affect the outcome of the suit under the governing law will properly preclude the entry of summary judgment. Factual disputes that are irrelevant or unnecessary will not be counted." And that's the Anderson case in your material. Mere sworn conclusions of ultimate fact, without a solid evidential basis or supporting affidavits by persons having actual knowledge of the facts, are insufficient to withstand a motion for summary decision. The respondent must do more than simply demonstrate some abstract or metaphysical doubt about material facts. Speculation, fanciful arguments, and disputes as to irrelevant facts will not bar summary decision. But a firm denial of having engaged in any misconduct with a soupçon of corroborating evidence may suffice to create adjudication-worthy issues, thus making summary decision inappropriate. Finally, I want to add some real cautionary notes about the summary decision process. Number one, a reviewing court, while not permitted to find facts, may supplant judgment on questions of law, and hence the court can make its own interpretation of law and substitute its interpretation of law for that of the agency. So if you issue a summary decision, it's going to be on a point of law. The court has the final say about that. There's going to be less deference generally than if you issue a decision following an evidentiary hearing. Review of a grant of summary judgment based on policy, however, should be very limited, and a court can only overturn such decision if found to be arbitrary. Number two, where the legislature has conferred discretion on an agency with the expectation that it will exercise judgment before withholding a license or benefit, the agency's failure to exercise discretion in favor of simple rote application of standards without hearing may result in a judicial remand for a proper evidentiary hearing. Judges, ALJs, and hearing officers should be mindful that agency prosecutors have an interest in promoting the cost-saving summary judgment procedure. The fact that they appear in every case may create a repeat player effect before certain tribunals and give them the ability to play for the rules, that is, select cases strategically to advance more permissive rulings, especially on the availability of summary decision. And one cannot dismiss outright the possibility of adjudicator bias in favor of repeat players. That may be something judges have in mind. Parties subjected to even formal APA hearings do not have access to the full panoply of discovery rights. And without effective discovery, a party opposing an agency's motion for summary decision is usually at a disadvantage. While courts routinely decline to enter summary judgment prior to the completion of discovery, should administrative tribunals act any differently? A switch from a full-blown hearing to administrative summary decisions, if repeated too frequently, may have a deleterious effect on enforcement of agency priorities, from matters that truly advance the public interest to other types of easier cases that target the weakest, perhaps pro se or small fry respondents. Of course, a pro se target of agency action might be the kind of individual who would benefit the most from an in-person hearing, where the presiding officer could ensure that she has a fair chance to make her best case. Summary decisions allow enforcers and adjudicators to do more with less, to bring and resolve more actions without expending more resources. It also allows agencies to pursue a different mix of actions. Summary decisions may facilitate the enforcement of certain rules that may not have been otherwise worth the cost to the agency of enforcing. While summary decision practice makes enforcement cheaper, it also makes easy but trivial cases much more attractive, particularly if agencies are under pressure to mount good statistics on how many cases they've resolved. Are they the right cases that the agency is focusing on is perhaps the better question. Efficiency and off-cited justification for summary decision procedure may be a less important value in the context of enforcement and disciplinary matters than, for example, initial licensing or benefits decisions. Do we really want agency enforcement practices skewed toward the lowest hanging fruit? So-called follow-on cases where a separate tribunal, be it a court or another federal regulatory agency or another state's authority, where a separate tribunal has found a respondent guilty, liable, or responsible for some infraction that can serve as the basis for further administrative action by your agency. These follow-on cases have been treated by many courts as a paradigmatic example of where it makes sense to make use of summary decision. But where the follow-on action consists of some administrative sanction, the administrative adjudicator should be exercising discretion and weighing factors such as the respondent's sincerity in assuring future compliance, the respondent's recognition of the wrongful nature of his or her conduct, the degree of scienter involved in the misdeed, and the likelihood of future violations. These factors seem to be exactly the kind of issues that an in-person hearing would be helpful to elucidate. They require credibility assessments and investigation into facts beyond those required to establish the underlying violation. Arguably, then, there should be a very heavy restriction on summary disposition in cases where motive and intent play leading roles or which involve a question of witness credibility. Moreover, collateral estoppel and other issue preclusionary doctrines do not necessarily prevent a respondent in an administrative proceeding from taking a position inconsistent with an admission of misconduct in a criminal proceeding. A criminal conviction may be conclusive proof of the commission of a crime, but not of the underlying facts. Motions for summary decision should be denied where a determination of material disputed facts depends primarily upon credibility determinations. Indeed, the summary decision process should eschew entirely the assessment of the believability of witnesses and their evidence. Similarly, where a pivotal issue concerns the respondent's state of mind, the tribunal should be loath to grant summary decision unless the proofs concerning the state of mind issue are so one-sided or conclusive as to render any evidentiary proceeding unnecessary. Fraud, misrepresentation, or acting in bad faith typically cannot be determined accurately without live testimony. So in short, summary decision is not appropriate where the governing standard turns on the factual context and the undisputed facts are scant, where facts in the record are not sufficient to establish either liability conclusively or the need for a penalty, or where credibility is at issue. Now, on the issue of sanctions, a few guiding principles, again stated in your materials. Number one, the imposition of a penalty is a matter of discretion. As the SJC wrote in a 1996 Board of Registration and Medicine decision, licensing agencies enjoy broad discretion to determine the proper sanctions for misconduct by professionals, and the court defers to the agency's expertise in making that determination. A reviewing court is not free to substitute its own discretion and thus should not disturb a penalty imposed by a board agency or administrative tribunal merely because the court's evaluation, or in the court's view, the penalty appears harsh. Absent the most extraordinary of circumstances, the SJC has written, an appellate court should refuse to interfere with the board's choice of sanction in a particular case. In the material, I cite the Fitzgerald case from 1987 for that proposition. I want to offer you a more up-to-date decision if you care to jot this down. The case is Thomann, Thomann versus Board of Registration of Real Estate Brokers, and it says salesman. I think that's kind of sexist for 2018, but the citation is 481 Mass. 1006, 1011, where the SJC also said that appellate courts consider only whether the sanction imposed was a reasonable exercise of the agency's sanctioning discretion. But of course, an agency may not exercise its discretion in an arbitrary or capricious manner. So the sanction imposed must be comparable to sanctions imposed in other similar cases. So said the SJC in the Coburn case in 2005. A 40-year-old appeals court precedent, the ABCC case cited on page 33 of your materials, is worthy of quotation here, and I quote, "An agency sanction requires the exercise of a certain amount of discretion, which is open to challenge only if that discretion is seriously abused and will not be disturbed unless the remedy reflected has no reasonable relation to the unlawful practices found to exist." Now, an appellate court will review any sanctions imposed for abuse of discretion. Case for that proposition is Anusavici versus Board of Registration and Dentistry. It's a 2008 SJC decision. And it's very important that the agency set forth the rationale in its decision for deciding to impose a particular sanction. I can't stress enough how important that is, to really explain the rationale to avoid a remand from a reviewing court. In Coburn, the SJC found that the board did fulfill its obligation under Chapter 38, Section 11 to state the reasons for decision, noted that the board's decision included a statement that it disciplined other state physicians for similar conduct. It's always good to explain the rationale for a sanction with reference to other agency decisions involving comparable conduct. As long as a penalty, however, is within the range contemplated by statute, the fact that the agency has imposed more lenient penalties on others for similar violations in the past does not render respondents' sanction arbitrary or capricious. Again, that's the Thomann case that I told you from 2018. A hearing, as I said earlier, should be provided in the case's sanction phase to allow respondent to present mitigating factors, explain actions, and address issues of appropriate sanction. But note that a party has no statutory or due process right to a hearing before the board on sanctions after a hearing officer does not recommend any discipline. Finally, I'd like to draw your attention to the teaching of an appeals court decision handed down just 6 weeks ago. I think the citation is in your material. It's the Blumstein versus Department of Public Safety case, where the appeals court reminded us that agency or board officials who have neither heard nor read the evidence may not increase a respondent's sanction without following the procedures that are laid out in Chapter 30A, subsections 7 and 8, which in short require issuance of a tentative or proposed decision stating comprehensive findings and rationale for decision, an opportunity to make objections to that tentative or proposed decision, and a formal explanation justifying the enhanced sanction. In the Blumstein case, the appeals court also said, and I quote, "An agency's compliance with statutes governing its procedures for adjudications that can result in the destruction of a person's livelihood is of sufficient public importance to justify judicial review, even if the respondent's appeal is moot, because the disciplinary sanction has been served." So clearly this is a matter that the courts take very seriously, the importance of explaining the sanction, and if it's a two-level thing where the fact finder is not the one imposing the final sanction, and the board or people who are voting on the final sanction have not heard or read the evidence, very important that they comply with Chapter 30A provisions about the tentative decision, allowing for objections, and giving a very detailed explanation for why they have enhanced the sanction. So those are my remarks on summary decisions and sanctions in the administrative adjudicatory process. We're now going to move into the judicial review phase of administrative decisions, and for that, I'm going to turn the stage over to Tim Casey.
Hi, everyone. Thank you, Rob. My name is Tim Casey. I'm Chief of the Administrative Law Division at the Attorney General's Office. It's a pleasure to be with you today. I'm really glad you're all here. Before we jump into court and start talking about judicial review of administrative agency decisions, I wanted to ask, Rob touched pretty comprehensively on the use of summary decision procedure and sanctions. Does anyone have any questions, or would anybody like to discuss any other topics related to practice or procedure before agencies before we get to judicial review? Okay. So now we're in court. And I'll be leading the discussion of judicial review under Chapter 30A, Section 14, our State Administrative Procedure Act. Michele Randazzo will be talking about the Certiorari statute, Chapter 249, Section 4. We'll also be covering and touching upon some other statutes like the Declaratory Judgment Statute, Chapter 231A, maybe a little bit about mandamus, and maybe a little bit about some other statutes. The outline that I'm going to be talking about starts at page 35 of your handouts. But I really encourage anyone who has a question or would like to raise an issue as we're going through the outline to please raise your hand. Feel free to ask a question. I want this as much as possible to be interactive rather than just me reading from our outline. You could do that just as easily at home. I want it to be useful and responsive to your questions and concerns. Some of what's in our outline is kind of in the nature of Administrative Law 101. So if you'd like to touch upon more masterclass level topics, we're happy to dive into those too. And got a very distinguished group of fellow panelists. I'm going to pose some questions to them from time to time. I hope they will also feel free to jump in whenever they like. So 30A14, as many of you know, sets forth essentially the default procedures for judicial review of a final agency decision by a party who is aggrieved by that decision. And I say it sets forth a default, both as to procedure and as to standards of review, because there may be a more specific statute that governs the particular agency in question. And so certainly if you're challenging an agency decision, you'll want to consult any agency-specific statutes to make sure that statute doesn't alter in any respect the default procedures set forth by 30A14. I think it's worth reciting a portion of 30A14 because a number of the elements of the statutory language are requirements and limitations on the availability of review under 30A14. And if you're a challenger who ignores some of those requirements, you may be subject to a motion to dismiss, or you may find yourself on the losing end of a motion for judgment on the pleadings. So 30A14 says that any person aggrieved by a final decision of an agency in an adjudicatory proceeding, and I'm at page 35 of the outline, all of those underlined words are legally significant and are requirements and elements of review. They are bases for dismissal of a 30A14 claim if those elements are not satisfied. And so you'll certainly want to make sure that you satisfy all those elements before bringing a case. A few nuts and bolts points right off the bat. Timing. A complaint for judicial review has to be filed in court within 30 days after receipt of the final agency decision. This is not a statute of limitations. This is a jurisdictional bar. If you miss the 30-day deadline, the court lacks power to hear your complaint. So it is critical, if you're the plaintiff, to file within 30 days after receipt of the agency decision. Service, the complaint has to be served on both the agency and the Boston office of the Attorney General's office, typically by certified mail. I will mention that we don't typically stand on improper service in the Attorney General's office as a basis to seek dismissal, but we may alert you to the fact that you haven't served your complaint properly. We may also ask for more time to respond to the complaint, if appropriate or necessary, on the basis of improper service. Venue, the case should be brought in either where the plaintiff resides or where the agency has its usual place of business, or in Suffolk County. Next, we're going to talk about stays of or injunctions against administrative agency decisions, and I'm going to turn it back over to Rob Quinan for a discussion of that topic.
So Chapter 30A, Section 14, Subsection 3, provides that the commencement of an action shall not operate as a stay of enforcement of the agency decision. Unless either the agency or the reviewing court grants a stay, the agency's decision will be enforced, and the person seeking judicial review is required to comply with the agency's decision, even while the action for judicial review is underway. That subsection further provides, however, that the agency may stay enforcement, and the reviewing court may order a stay upon such terms as it considers proper. Now, counsel for an aggrieved person appealing to court and desiring to preserve the status quo pending judicial review of the agency's decision should generally first seek a stay of enforcement of the agency's decision from the agency, and only if denied, then from the reviewing court. Particularly with certain agencies, counsel for a plaintiff might feel that asking the agency for a stay would be futile. But that thought actually should be resisted if plaintiff is definitely prepared to seek judicial review and believes that strong grounds for a stay exist. Why? Bear in mind that the Attorney General's office has a lot of sway when it comes to meritorious claims for a temporary stay of enforcement, and we represent all state entities. And we will be, at least initially, less caught up in the passions underlying a hard-fought case. If the adjudication dealt with a novel or a complex issue, the agency may be more apt as a general proposition to grant a stay of enforcement pending judicial review than if the adjudicatory proceeding presented routine, relatively uncomplicated issues for agency determination. The agency is also more likely to respond favorably to a request for a stay of enforcement of its decision where the consequences of the decision are far-reaching or its immediate impact upon affected parties is substantial, and significant legal issues will be involved in any judicial review proceeding. At bottom, a request is a matter for the exercise of sound discretion by the agency. That said, I am hard-pressed to imagine a situation in which a plaintiff has a solid shot of getting a stay from a court, and it would be futile to first seek a stay from the agency, so long as counsel timely conveys to the Attorney General's office the inevitability of litigation and the merits of a stay. There certainly are occasions on which the Attorney General's office will defer in the end to an agency's strongly held view that a stay is not warranted, but we will always have a discussion with agency officials, and ultimately the Attorney General has the final say on litigation strategy. We may advise the agency that we will not oppose a motion to stay, even over their objection, if the situation calls for a more moderate approach. That might be enough to get an agency to come around and perhaps grudgingly grant a stay. So why not, if you are the plaintiff's counsel, take 2 bites at the apple? Bottom line, although there is no rule that a person seeking a judicial stay of enforcement must first have sought and been denied a stay by the agency, doing so is usually the better course of action. But if you do have to go to court for temporary relief, what do you have to show to get a stay? Well, federal courts, at least, have followed the U.S. Supreme Court's lead in effectively equating the standards applicable to adjunctive relief and those governing a stay pending judicial review, uniformly imposing essentially the same requirements, including likelihood of success on the merits, irreparable injury absent a stay, a balancing of relative harms, and the public interest. Now, at least as of last year, when I prepared these remarks, no published Massachusetts appellate decision appeared to have definitively announced the factors justifying a stay pending judicial review, but lower courts routinely apply the preliminary injunction standard. In large measure, a request for judicially ordered stay of enforcement is addressed to the sound discretion of the reviewing court. But there are stringent standards. So what do you have to show to get a TRO or PI relief in court? Well, Rule 65 provides for 2 kinds of TROs, ex parte TROs and TROs with notice to the adverse party. As a general rule, ex parte TROs are disfavored by all courts and should seldom be sought, except in rare and unusual extreme emergencies in which it is probable that truly irreparable injury will occur before a PI hearing can be held. Most judges dislike granting relief, even of such a short duration, without affording even minimal notice to the affected party. They tend to place an exceptionally heavy burden on the movement to demonstrate the actual imminence of an exceptional injury. And the frequently exaggerated effort to do so tends to undermine the movement's credibility with the court and chances of success in the subsequent PI phase of the case. Now, TROs with notice are a different story. Oddly, neither the state nor the federal Rule 65 sets forth specific standards for granting them, or for what happens when one wants a PI thereafter. But a TRO is only supposed to last for 10 days, and the standard should be the same as for a PI. Although TRO relief with notice is routinely nominally requested by plaintiffs along with PI relief, in fact, it is frequently bypassed by plaintiffs who proceed directly to the PI process. I think that that's often a mistake. More often than not, an agency can live with a standstill order for 10 days, even if they don't like the idea. Consequently, the Attorney General's office is less likely to fiercely resist a TRO than a PI that might last for months or even longer. Now, the basics of PI law I won't go over because of the limited time we have today, but bear in mind that a PI is designed to prevent imminent as opposed to merely potential harm in appropriate circumstances until the respective rights of the parties can be sorted out in further proceedings. It's an extraordinary remedy, never awarded as of right. Purpose of the PI is to preserve the status quo, to preserve the relative position of the parties until judicial review can be held. To get a PI, the plaintiff has the burden of presenting evidence demonstrating 4 things. Number 1, that she has a reasonable likelihood of prevailing on the substantive merits of the case. Number 2, that she has no adequate remedy at law, such as quantifiable or collectible monetary damages, a requirement that's almost always satisfied by the proxy showing that a plaintiff will suffer irreparable harm that cannot be assuaged by a final judgment at the end of the case. Number 3, that the harm to the plaintiff if injunctive relief is denied will be greater than the harm the defendant will suffer if relief is granted. And number 4, in our government cases at least, that the granting of injunctive relief will promote the public interest, or at least will not adversely affect it. One little note I'll make here that courts of equity should not, except in limited situations involving overriding public interest, grant the applicant through a PI all or substantially all of the ultimate relief he or she would be entitled to if victorious after a full hearing. Now, a few practical pointers for PI or stay litigation. First, tips for plaintiff lawyers. I would say as early as possible, engage the other side's lawyer. The possibility of a negotiated settlement or mediation of the underlying controversy may represent the most rational and efficient course for both sides. And remember that the Superior Court rules do encourage, if not require, conferring with opposing counsel before filing motions with the court. Number 2, don't dither. The passage of time can seriously weaken a prayer for relief. On the other hand, it is important for plaintiff's counsel to resist the impulse to proceed on a cursory or incomplete factual investigation. In PI litigation, the plaintiff's counsel should know at the time of filing the application as accurately as possible which facts will be provable through what types of evidence and what documents can be presented to the court to persuade the court to grant the preliminary relief. Remember that PI papers must be verified. A PI motion must rest on either a verified complaint or one or more supporting affidavits stating the facts. Factual representations of counsel are insufficient. Our appellate courts have so held. It is not, however, required that all the evidence supporting a PI application be admissible at trial. In other words, some may be hearsay, so long as it's reliable enough for the judge to accord it some weight in his or her decision. Next point, get your papers in early. If at all possible, papers should never be presented to the judge in open court. And fairness, of course, dictates getting papers to one's opponent in time for her to at least read them before getting into court. With the clerk's approval, copies for the judge's review may be emailed in, with copies also emailed to the other side to avoid charges of improper ex parte contact. Both parties' counsel should have an extra set of papers for the court, just in case, and definitely copies of any particularly key cases to hand up at the PI hearing. Final point for plaintiff's counsel, don't insist upon an immediate hearing. In the absence of a true emergency, a hearing should not be scheduled sooner than several days after service on the Attorney General's office of the papers. Unfortunately, it's way too common for us to receive papers only one day or maybe 2 days before a hearing, and we will not be shy about letting the court know that, because oftentimes plaintiff has gone to court a full week or more and requested a hearing, and for whatever reason it takes 4 or 5 days to get service on the Attorney General's office. That's not kosher, and you should not do it unless it's a true emergency situation. The court risks not getting the full story at the PI hearing or having to delay proceedings to reschedule them or to give time to defense counsel to pull together materials for PI if you don't provide several days advance notice. So we do encourage you to get in touch with defendant's counsel, serve the papers as soon as possible, and don't try to jam the other side. Now, tips for the recipient of a PI motion. First, I say keep calm and carry on. Don't panic. When the case comes in, it's probably the first that at least an assistant attorney general knows of this controversy at all. I mean, this may be a dispute that's been going on for years in an administrative tribunal or some other setting, but it's just now coming to court. Of course, we know nothing about it. So the temptation is to kind of panic and think, okay, how am I going to deal with this on 48 hours notice? But there is a lot of institutional knowledge, a lot of experienced individuals, and generally very helpful agency counsel and agency officials that can help provide you with the information you need to present to the court regarding the PI motion, even on very short notice. You'd be surprised how quickly you can gather information. I was just in court yesterday on a PI hearing at 2 p.m. I received the papers at about 4:30 the afternoon before. I had other commitments the next morning. So I had about really no more than an hour to get the information necessary. It happened, and the PI was denied. It can be done in a very short time period if necessary. But normally, you would want to do a careful review of all the papers, look at the statute, any statute that may be involved. That was the key in my case. I took a look at the statute first thing, and I realized the court didn't have jurisdiction. All right? If the court doesn't have jurisdiction, the court can't enter a PI, right? Look at the statute, look at the papers, interview whoever in the agency you think might have information knowledgeable about the allegations of the complaint, do a preliminary evaluation of the merits of the case, be thinking about all the defenses that may be available, like lack of jurisdiction, but also standing, statutes of limitation, any other failure to exhaust administrative remedies. Contact opposing counsel and discuss the possibility of settlement or an agreed upon stay. Many judges will want to know if the parties have discussed the matter before appearing for the first time before the court, and they won't necessarily look with favor on attorneys who say that, nope, we've never spoken about this matter. So another good reason for lawyers to consult before the PI hearing. You might, as a defense or assistant attorney general, ask opposing counsel to consent to a postponement of the PI hearing. And sometimes plaintiff's counsel will accept a standstill agreement between the parties that reschedules the PI hearing, but freezes the status quo until the judge acts on the motion. It's the functional equivalent of a TRO without the enforcement trappings. If you have sufficient time, you should always prepare an opposition to the PI motion supported by opposition affidavits. The defense should focus on obtaining as many carefully drafted and detailed personal knowledge affidavits as possible in the relatively short time frame available, with a view toward exposing potentially false or misleading allegations in the plaintiff's complaint or supporting affidavits, and to setting forth the defense side of the story and persuading the judge that the facts and the equities require denial of the PI motion. The number and quality of the defense's affidavits can have a significant impact on the outcome of the motion, so great care should be given to ensure that they are accurate, complete, and as natural sounding as possible. And this, of course, is where agency officials, agency lawyers can come into play, even if it's an assistant attorney general that's largely is going to be the one appearing in court.
Rob, can I just jump in here for a minute? I just want to echo what he just said. For those of you who are agency counsel, it's not just a role you have to play with respect to the affidavits. We consider it your responsibility to develop the affidavits that are going to be in support of an opposition to a preliminary injunction motion. So you're the experts on the facts. You have lived with the case possibly for a long time. So in the division of labor, at least between the Attorney General's office and our agency counsel clients, it really is the responsibility of the agency to develop the affidavits that will be submitted to court that either demonstrate why, in the agency's view, there's no likelihood of success on the merits, or there's no irreparable harm, or the public interest favors denying a preliminary injunction motion.
Now, on the other side, I see we have a question back there.
Would you wait for the microphone, please?
Microphone, please.
I wonder if you could just say a little more about the relationship of agency counsel and the Attorney General's office. I know the AG's office is always notified and typically appears on appeal, but it seems often at the trial, the Superior Court level, the agency lawyers are appearing and the AG is not involved. And I'm just curious how that works, if it varies with the agency, with the issue. As plaintiffs' counsel, if we have any druthers, with any tips there?
So if you represent plaintiffs, I'm sorry to say you don't have any say in that. It really is an agency by agency arrangement that our office has with various agencies about whether and to what extent agencies will represent themselves in proceedings in the trial courts through a special assistant attorney general designation. In the appellate courts, we generally handle most, if not all, matters on behalf of our agency clients. In the trial courts, depending on the volume and the specialized nature of the cases, we often agree to allow agencies to handle their own matters, or at least some of them. But those are agency by agency arrangements that are worked out between our office and our agency clients.
Any other questions? Sure.
Wait for the microphone, please.
In terms of agency counsel or the assistant AG, another player typically, and perhaps this is what Michelle's going to be covering, is the municipality. If it's a local board decision that's involved, who's responsible for ensuring that the local community is part of the Superior Court action if the plaintiff in that case does not name the local board or the community as a party when they appeal an agency decision?
So I would say, first of all, that I have a stock email that I will send to plaintiffs' counsel if I feel that they have failed to name a necessary party. And that often does happen with respect to, for example, Civil Service Commission appeals, where the dispute is really between a municipal employer and a municipal employee, and the commission has decided a case. It's now on appeal, and if it's the employee that fails to name the municipality, I will get in touch with counsel for the employee and say, hey, and I cite this wonderful appeals court decision that basically says, failing to name the city as a co-defendant is like staging a play of Hamlet without Hamlet. They are a necessary party. So I will always make sure that they have a chance to be made aware of the litigation and that they should be part of it.
But Rob, just on that point, assuming that you don't get any play from the plaintiff's counsel, they don't take your suggestion that the employer, the city, the town be notified, would you folks then turn around and give us the heads up? Because I don't know necessarily that we always are aware. I mean, I think we generally have an idea when those things go to a court level, but we may not always be on notice.
Yeah, I would, if I know who counsel for the municipal entity is, I will be in touch and say, do you want to move to intervene? But I may very well say to the plaintiff's counsel, if you don't name them, I'm going to move to dismiss for failure to name a necessary party. And I think I definitely made that threat. I don't recall whether I've followed through, but it's a real threat.
One more question.
A question on mechanics of involving the AG's office. So I represent plaintiffs in situations where we frequently are filing a motion for TRO with our 30A complaint because it's a poverty program. People are terminated on very short notice, sometimes less than one business day. So I understand the requirement of serving the AG's office, but in terms of reaching out to someone to have a substantive conversation about a request for TRO on that sort of time frame, I often don't know who at the AG's office is potentially going to be assigned the case, et cetera. I wonder if you have any thoughts about how to navigate that. We're usually just discussing with agency counsel, but I'd love to reach out to the AG's office if possible.
Sure. So I will say that if the relief that you're seeking in the litigation is injunctive or declaratory in nature and is not monetary in nature, and you're not getting satisfaction from an agency counsel in terms of some kind of standstill agreement or a temporary stay, I'm going to regret this, but I'm going to put out there that, call me. I'm managing attorney in the Administrative Law Division. I probably will be making the decision about who gets the case if it's a 30A case. And I would prefer to know, as soon as possible, that you are in fact going to be moving for a preliminary injunction or seeking a TRO with notice. Please call me, and I'll make sure that whoever ultimately handles the matter gets looped in as soon as possible. If there are no more questions, we had been talking about affidavits and Tim's point about the important role that agency counsel play in getting affidavits on the defense side. Well, as defendant's attorney, one other thing to look at is the plaintiff's affidavits or the verified complaint. If they're not based on personal knowledge or otherwise improper, defendant's lawyer ought to be giving some consideration to moving to strike in advance of the PI hearing. Otherwise, harmful and inadmissible hearsay can be considered and relied upon by the court. If support for the complaint can be whittled down to information and belief assertions on the central issue, the court may well reject the PI motion. Don't risk waiver of sovereign immunity where applicable by saying that the possibility of damages after a case is resolved precludes a showing of irreparable harm. Because if you're going to assert sovereign immunity, your position is that there are no damages available. You're going to have to attack irreparable harm on some other basis. Do enhance credibility by effectively conceding irreparable harm when appropriate, especially if plaintiffs seem very sympathetic. But place the plaintiff's harm in context. Argue non-likelihood of success on the merits, and point out all countervailing equities, especially the public interest, if it particularly favors the agency's action. Having affiance and agency personnel, if not present in court, at least promptly available by phone, by text, as well as properly prepared at a PI hearing is a very prudent course, particularly if the fate of the motion depends on a critical disputed issue of material fact. If possible, have agency counsel sit next to you at counsel table for the PI hearing. Now, at the PI hearing itself, your presentation at the PI hearing invariably calls for great focus and clarity and prompt response to all the judge's questions. You should arrive to court as early as possible because your opponent may very well have just filed or will be about to file additional papers that you must review, which may require the preparation of supplemental affidavits or a quick call to your agency client. If you're the one seeking injunctive relief and the judge seems unwilling to grant the full injunction requested, be prepared to present lesser alternatives to the judge that provide at least some of the relief sought, explaining that the matter can thereby be resolved fairly to the plaintiff and with a minimum of harm to the other side. If the court begins to sound as if it is considering expediting the case, the plaintiff should not resist too strenuously because it probably signifies that the court is having doubts about granting the PI, and the choice of no injunction but speedy judicial review is usually preferable to no review at all, or no relief at all. The bottom line in injunction practice is to be realistic and practical and not overreach, either as plaintiff or as defendant. If the court seems to be leaning toward concluding that a PI of some sort is warranted, the plaintiff should be careful not to push for too much, since in most cases the judge seeks a fair result by granting the minimal order that will preserve the status quo until the merits can be disposed of. Nor should defendant too strenuously persist in opposing any sort of preliminary relief in such a situation at the risk of appearing inflexible. Remember the broad reach of the court's discretion to avoid, as plaintiff, ending up with nothing, or as defendant, bringing upon yourself a more restrictive result than otherwise might have been imposed. I think we'll move on from this topic unless there are any other questions.
Well, can I just make a few comments? Because when you're moving from the agency to the court, you have an audience, and the audience is us, the judges. And a lot of times I get the impression that people are so wrapped up in the dispute that they've been having so far that they kind of forget our perspective. So if you're coming into court saying there's no substantial evidence for a particular finding, you might be right, but I don't have the record. I've been asked many times to resolve a substantial evidence question on preliminary injunction, and I have no clue. And it's not the party's fault. It's just that I can't ascertain who's going to win when the record's filed. There's a couple of responses to that. Obviously, always look for legal error if you can. Look for an error that's evident on the face of the decision. I mean, sometimes the hearing officer is very conscientious, but inadvertently discloses a huge flaw. There's only a limited amount of material that you can give me that will show that the agency made an error. So if your argument is substantial evidence or something that's going to require a more extensive review of the record before I have any idea who's likely to win, you might consider an expedited preparation of the record. I'm sure we're going to get into Standing Order 196 of the Superior Court, which sets out I would say somewhat leisurely, but I don't think the people who have to put the administrative records together would agree with me, but it's a somewhat leisurely pace. But often I've found that if I really have a case that really does need some resolution quickly, that the agency is willing to move forward and filing the record earlier than they otherwise would. Sometimes the parties are willing to help out, particularly if the agency is in the position of basically being a neutral adjudicator, not an enforcer, not in a position where they're actually developing their own policy, but they're just trying to adjudicate a dispute between private parties. Often the parties are able to get it done. So be creative about how that record can be compiled and presented to me quickly. Obviously, one thing that I can do is assess the harms on each side, and one of the questioners already pointed out that if there's somebody losing housing, they're losing some kind of benefits, that's a pretty serious issue. And so in the course of figuring out what I can and cannot do, that looms pretty large because I can see that, and it's hard to ignore. Also, even if you have a commercial case, your client's been put out of business, they've lost a license, or they've been given a suspension or something like that, that I can clearly understand. So I think it's important always, no matter what you're litigating, to try to think about the perspective of your audience, which may not be your own perspective. It does take some imagination.
So we're going to move on. And just so you know, this outline is organized essentially chronologically in terms of the life of a case in Superior Court seeking judicial review of an agency decision. I'm going to try, I'm glad we've got more time than we have in prior presentations, but some of these topics we can breeze through pretty quickly. Standing, I just want to highlight that the plaintiff has to articulate substantial injury as a direct result of a breach of a duty owed to it by the public defendant. And this is an important corollary to that. Merely because a plaintiff was allowed to participate in the proceedings before the agency does not mean that they have standing to challenge the agency's decision in court. As many of you who represent or are involved with agencies know, you often have broader, more flexible rules about who can appear before and participate in your administrative proceedings. But merely being able to participate below does not mean you'll have standing to challenge the agency's decision in court.
Tim, if I could just jump in. We've cited in the materials some cases on that point, but I just wanted to draw your attention to a more recent decision that's cited elsewhere in the materials for another proposition, but also does speak to this issue, that merely being able to participate, even by virtue of a regulation that allows you to participate in the proceeding below, does not necessarily mean that you meet the standing requirements for court. And that's New Bedford Educators Association versus the chairman of the Mass Board of Elementary and Secondary Education. You'll find the full citation on page 51 and footnote 70, but it's also relevant for this purpose as well.
finality. The decision that's being reviewed in court has to be the final decision of the agency. This is, there are two species of finality issues. One is the requirement of exhaustion of administrative remedies. So if a party has initiated proceedings before an agency but hasn't concluded them, or maybe there are multiple levels of administrative review within an agency or among several agencies before you get to go to court, if you haven't exhausted all of those requirements, you may be subject to a motion to dismiss for failure to exhaust administrative remedies. Related to exhaustion is the notion of primary jurisdiction. Sometimes a party will run to court even seeking declaratory judgment, but without having presented in the first instance some aspect or all of the dispute to the agency that by statute is charged with adjudicating it in the first instance. And if you do that, there may be an argument by the agency or by our office that primary jurisdiction compels you to go back to the agency or to start with an agency to have it resolve some or all of the dispute before getting judicial review.
And I'll also chime in with another new case citation on the question of whether or not an agency decision is final. There was a case from earlier this summer, Grandoit versus the MCAD. It's an appellate decision, 95 Mass Appeals Court 603, and further appellate review on that was denied in October. And so it's not a lengthy analysis, but it does go through the steps of how a court would determine whether or not an agency, proceedings for an agency constitute a final action that's appealable in court.